Okay, this is Professor Herskowitz, and we're going to take just a few minutes and talk a little bit about agency. It's especially important as we go on and start talking about employees' responsibilities and the different laws governing employment contracts. Okay, the learning objectives for the agency is to understand how the agency relationships are formed between the principal, the agent, and then a independent third party. And we're also looking at the fiduciary duty that an agent has to his or her principals. Very important concept because most of you will end up as agents in some capacity or the other. And this responsibility that you have as an agent is important to understand. Organizations have to operate through their agents. There is no way a corporation obviously can do anything other than through the officers and employees. And so it's important to understand the roles of the principal in an agency agreement, the agent, the third parties, and also an independent contractor. We're going to talk about that in just a minute. The contractual liability from an agent's acts, there's different types of authority. There's actual, implied, and apparent as it relates to an agent. Tort liability, the principal is responsible for the torts of his agent, especially as employees, under the respondeat superior concept, which we'll talk more about in the future. And then the criminal liability from an agent's acts, typically the principal is not liable for the criminal actions of an agent. However, there is negligent hiring where a principal may be liable for the criminal actions of an agent if they should have known that the agent had a propensity to do such criminal actions or had actually done them in the past. Okay, what is the relationship? Well, you have a principal and an agent. They sign an agreement or they enter into an agreement. You then have an agent and a third party, some contract or action that's taken that involves a third party. And then you have the third party's relationship to the principal itself. So we look at all three of these and we see that a contract negotiated by the agent with a third party on behalf of the principal will bind the principal to that third party. The agent himself or herself is not liable under that contract. The contract is between the agent and the third party is actually binding to the principal itself, not to the agent. We also have a relationship called an independent contractor, and this is not an agency, although sometimes it appears to be. You have a principal with a relationship with an independent contractor, and then the independent contractor will negotiate with a third party. In that case, only the independent contractor is liable. There is no liability for the principal and the third party. Independent contractors are paid and then they must take care of their own taxes and insurance. There's no ongoing relationship between an employer and an independent contractor. The relationship is over once the job is completed. And employers are not liable for the torts of the contractors of independent or contracts of independent contractors. There's some exceptions to that. We talked about that for under torts under the strict liability. If a principal hires an independent contractor to do an extremely dangerous operation, the principal will still be liable even though it is a third party contractor. That happens in demolition type of contracts where the principal will hire the independent contractor to demolish a building. However, the principal is still liable for the actions of that independent contractor. Those types of risks are usually covered through insurance provided by the independent contractor. And the employers are not responsible for various employee taxes of an independent contractor. This comes into a lot of play when the government is taking a principle such as Microsoft or especially the software companies. Instead of hiring employees, they end up hiring a lot of independent contractors. And the Department of Labor comes in and tries to attack that and say they are not independent contractors. They really are employees. But the employer is trying to save on unemployment taxes and other benefits that they would have to pay. And so that's where the legal tension arises between independent contractors and principals. An agency arises whenever one party controls the actions of another. That controls is the legal word or the legal concept, and how much is enough to make it an agency and how much is to leave it as a third-party contractor is what many lawsuits are about. You do have express agencies, and that's where the agency occurs when a principal and agent expressly agree to enter into an agency agreement with each other. This would be, for example, a homeowner listing their home with a real estate agent. The implied authority, there is implied authority that comes along with the express agency that is necessary to accomplish the legal actions of the express agency. So there are certain things that you look at and you say, if you're going to act as an agent in this situation, there are other things you have to do, and that's the implied authority. You don't have to spell out every single jot and tittle on the agency agreement. There are some aspects that are just common sense and that are implied that go along with that express agency. Different types of employment relationships. You have an employer-employee, the relationship that results when somebody is hired to perform some type of physical service. They have very limited, if any, agency responsibilities. You have a principal agent, and this is where the employer hires an employee and gives that employee authority to act on behalf of the corporation or the legal entity. This is usually officers of the company. That raises it to a higher level of accountability for the principal when its officers enter into contracts or when they cause some kind of a tort. Then there's a superior, the respondeat superior liability will attach to the principal as well. Principal independent contractors, as I said, the relationship is independent of the two. It is strictly a contract between them. Employees hired by the independent contractor do not have any liability or impose any liability to the principal of the agency relationship. Agent's duties, and this is an important part, because when you become an agent, you actually have to act at times to your own detriment to the benefit of the principal. That's called a fiduciary duty. The fiduciary duty is made up of several different categories. You have a duty of loyalty. This is the interest of the principal must be above your own interest. For example, if you're working for a company that's investing in real estate, you find a good investment. You're supposed to be going off and buying apartment houses. You find a really nice investment. And you say, boy, I'd love to buy that myself. Because you owe this fiduciary duty to the principal, you cannot. You must forego your own interests and then act in the interest of the principal. As an aside, if as an agent you find that and the principal decides not to purchase that building and they reject it, you then may purchase the building. But there has to be clear disclosure and the opportunity for the principal to first buy that building. And that happens in all aspects of agency-principal relationships. The duty of obedience. An agent must follow the instructions of the principal. And the duty to inform the principal of any relevant facts relating to that the agency learns in their role as an agent. You have to keep the principal informed because the principal is presumed to have the same knowledge as the agent. And so this can attach liability to the principal, and if they don't know about it, the liability attaches anyway. So that would be a breach of the agent's duty to inform. And there's a duty to exercise due care in carrying out the responsibilities. And finally, there's a duty to render an accounting. The expenses and income received by the agent need to be reported to the principal so they know exactly how much they've made or what their costs are. Agent's liability. There's no liability for contracts entered into on behalf of the principal. There is a exception to that, though, when the agent is acting as an undisclosed agent. An example would be somebody buying land in Florida for a new Disneyland. Disney hired a number of agents to buy the land on behalf of Disney because they knew the prices would go a lot higher if people knew that Disney was buying. In that case, if Disney had defaulted on any purchase, both Disney and the agent would be liable because the agent did not disclose the agency themselves. If an agent enters into unauthorized contract, agent is personally liable. The gray area here comes when the principal is liable for a authorized agent exceeds his or her scope of authority. The third party is not responsible for determining how broad is the authority of the agent. And so if the agent has authority but they exceed it, that will still bind the principal. The difference here is that the principal could then be liable to the agent would be liable to the principal for any costs exceeding his or her authority. So while the third party can collect from the principal would be able to collect any excess costs because of the agents exceeding their authority. Different types of agency agreements that you see: employment agreements, usually dealing with officers of a company. Be careful, independent contractors are not agents. They are just it's a contract relationship between the principal and that independent contractor. Real estate brokers, conservatorships, powers of attorney clearly designate agents, and anyone that you empower to do something for you will actually be your agent. Okay, fairly short video this time, but important on understanding, especially as we move forward and look into the role of the responsibility of employers and employees. Thank you very much.